Thank you very much. So I'm joined here on the stage with Stacey Slaughter to my right and Michael Mallow. And let me start by introducing Stacey. Stacey is a partner and co-chair of Robbins Kaplan's Antitrust and Trade Regulation Group. For over 25 years, Stacey has regularly served in court-appointed leadership roles representing clients whose rights have been compromised or who face significant commercial disputes. Stacey's cases in her cases, she has recovered more than $6 billion for victims of deceptive or unlawful conduct, and her cases have included some of the largest, high-profile, and most innovative cases arising under the antitrust and securities laws. She currently represents plaintiffs in various antitrust class actions, including the representation of a proposed class of U.S. multifamily housing renters against property management software company RealPage and the landlords that use its software, a class of consumers who purchase granulated sugar manufactured by the largest sugar producers in the United States, and a class of cattle ranchers and industry trade groups alleging that the country's 4 largest meat packers colluded to suppress the prices paid for cattle. She's also represented a class of over 10 million U.S. merchants who allege that Visa, MasterCard, and their member banks violated the antitrust laws by charging super competitive interchange fees on card transactions. So that's Stacey, mostly on the plaintiff side. Michael, by contrast, is the managing partner of Shook Hardy and Bacon's Los Angeles office and is the co-chair of the firm's class action and appellate practice group. He's an experienced trial lawyer who represents clients in class action and complex litigation matters, including cases related to economic product defects, unfair competition, false and deceptive advertising, business torts, privacy, entertainment, and intellectual property. He has served as lead trial and appellate counsel in a number of pivotal consumer class actions, including a number of prominent ones, but I'll name, for example, Sandvelt, I mispronounced that undoubtedly, versus Mazda Motor of American, and Grodziski versus American Honda Motor Company, both in the Ninth Circuit. He's the immediate past president for the Los Angeles Association of Business Trial Lawyers and is a member of the California Civility Task Force. He was recently selected to serve as a Ninth Circuit lawyer representative and has received numerous accolades, including rankings in chambers. So with that introduction, I'll ask a question of our panelists. And let me start with a question I've recently seen in my own practice. And the way I've seen this is doing a class certification opposition. I'm more on the defense side myself. And I said to one of my colleagues, there must be a case saying if you have an uninjured class member, you can't certify class, right? And he said, no, actually, that's not true. There's a circuit split on that. And I said, really? And he said, well, actually, the Supreme Court's about to take it up, so we're going to have some clarity soon on this issue. Don't worry, by the time we have to brief this, we'll know what the answer is. Much to my chagrin, it turned out the Supreme Court didn't take up the issue. So let me start with this question. Maybe I'll ask you, Michael. Why didn't the Supreme Court address whether an uninjured class member could defeat class certification? So, in the United States, the class action mechanism flows from Rule 23. And under the Rules Enabling Act, which is an old statute that says, you can create these federal rules of procedure, including Rule 23, the principle is that the rules can't modify, enlarge, or abridge a substantive right. To me, maybe because I'm a defense practitioner, it seems if you have an uninjured class member who could be part of a class, you're at least enlarging a right. Why is that wrong, Stacey?
Well, I think the issue, and just to pick up on what Michael said, is the timing of this decision. Should that happen at the class certification stage, or can it be dealt with at at the claims administration at the damages time, right? Because, if the class definition satisfies the predominant prong, right, as long as the uninjured members can be identified and excluded, what's the real harm here? And what I'll say in addition, so you're talking about why the Supreme Court punted. I think there's plenty of Supreme Court dicta, if you will, to support sort of this view. And I'll start with the Tyson Foods case. There they affirmed a class certification despite the presence of 212 class members who were not damaged, who were not injured. There's more, Spokeo. Even when you have like named plaintiffs, those named plaintiffs have to allege injury and show injury, right? But they don't have to show that injury was suffered by other unidentified members of the class to which they belong. That's the Spokeo case. The Halliburton case. While the defendant might attempt to pick off the occasional class member here or there through individualized rebuttal, does not cause individual questions to predominate. So that's more of a predominance versus an Article III standing question, but I know there's a debate on whether, I think Gorsuch said in part in this opinion that it was more of a Rule 23 question versus a constitutional Article III standing question. You've got the Amgen case and the Dukes case. I won't bore everyone with where I think there's at least dicta to support this view.
I see. Now we can have like an appellate oral argument here because we have a very different perspective on this.
Yeah, let's hear it, Michael.
So it's interesting because if you look at the facts of LabCorp, the injury that the court was focusing on was the fact that under the Americans with Disabilities Act, there had to be an adequate alternative for disabled people who, in this case, wanted to use a kiosk. And the kiosk was supposed to be a purportedly a quicker, easier way of engaging with the company. But the company did offer in-person folks to deal with anybody who might have disabilities, and the court basically said that the Ninth Circuit granted certification, notwithstanding the argument that some people, some disabled people, may not have wanted to use a kiosk because they'd rather deal with a live person than use a kiosk. It's interesting because there are two other Ninth Circuit cases that actually go the other way on this issue. And in the insurance context, one is Farley versus Lincoln Benefit Life, which was decided August 29th of this year, and Small versus Alliance Life, which was decided last year. And in both of those cases, they involve notices to insureds that they had not paid their premium. So you have to, under California law, provide 30 days notice before you cancel a policy. And in both of those cases, class certification was denied because there were people in the class who purportedly were not injured. And the basis for that opinion was some people may have wanted their insurance policies to lapse. And therefore, the failure to provide notice didn't injure them because they didn't want the policy to continue anyway. And to me, having non-injured people because they didn't want their policies to continue sure sounds a lot like there are uninjured people in the class in LabCorp because they didn't want to use a kiosk. So it's, the case comes to the Supreme Court from the Ninth Circuit. Oh, is it still not working? All right. Yeah, just keep on that one. Keep on this one? All right. There we go. So you have the Supreme Court, in the LabCorp case, where the uninjured people are people who may not have wanted to use the service. Sure sounds a lot like the insurance context in Farley and Small, and all of these cases come out of the Ninth Circuit.
Let me take this to a wild place, okay? So here's the thing. There's certainly a difference between certifying a litigation class and certifying a settlement class, right? And
Well, can I push back on that? Why should there be?
Well,
I know that the cases say what they say.
Let's be in the pretend world for a minute.
Sure.
So defense counsel often want to include as many potential class reps as they can when they want to get a settlement, right? If we go down this road, what impact is that going to have? And I know there are slightly different standards for certifying class. You're smiling. What impact is that going to have on settlements? and you're certifying a settlement class, and the definition of a settlement class and uninjured plaintiffs. I mean, just think about that for a second. Anyway, just.
Well, and I would argue that when the parties come to an agreement on how a case should be resolved, that a lot of the rules, as long as the class, those settlement class members are protected and are being treated fairly, and that's the court's job to make sure that happens, you can get away with a lot when everybody's in agreement versus when we are not in agreement. And of course, we have the INRI, Hyundai and Kia decision out of the Ninth Circuit, which really does recognize the difference between settlement classes and contested classes.
A lot of cases do, but let me take Stacey's hypothetical and twist it a little bit further, because I'm interested in where we're going here. We're talking about uninjured class members, but what if we're talking about claimants who don't even have a claim that are in the class? Because the substantive law in a nationwide class, for example, just doesn't recognize the cause of action. In the interest of global peace, should they be able to have a settlement class certified and everybody just moves on and goes off their merry way?
Not sure I understand the question. Sorry.
Yeah, so let's take an example, Illinois Brick, right? It says you can't have a claim as an indirect purchaser for damages. You have a nationwide class of direct purchasers, and both Illinois Brick repealers, non-Illinois Brick repealer jurisdiction. Should we allow class certification of a nationwide class that includes both the claimants who have a claim because they're direct purchasers and the claimants that don't? Global peace, right?
It presents some interesting issues on settlement. Certainly, if it's a contested class, the answer is no. But on a settlement, again, so long as all of the settlement class members are being treated fairly, then I don't see necessarily a hurdle for that. So long as the standards for fair treatment of settlement class members is being acknowledged.
Well, let me ask this. The Supreme Court punted on this issue of uninjured class members. What impact is that having on your practice, both on the plaintiff side and the defense side? Maybe starting with you, Stacey. What impacts are you seeing?
Well, I mean, so far you expect the argument from the defendants, right? And I think in LabCorp, the fix was fairly easy. It was a fairly easy, it was mooted because the class definition changed, and that it was pretty simple fix for the class definition. I think when you get into some more complicated cases, it's almost conflating, what the plaintiffs will ultimately have to prove in the fray with, how you're defining the class. So,
what's your perspective, Michael?
I think, quite honestly, the whether all class members need to be injured question is not a particularly difficult one. I think the answer ultimately is going to be yes. You have to have class-wide injury in order to certify a class. And could you have some, minor exceptions to that that will be identified in a claims process? Potentially. But overall, I think the answer is going to be you need to have class-wide injury to essentially comport with the superiority requirements of Rule 23. The much more difficult question is, what does the injury need to be? So to give some examples, again, in LabCorp you have, is the injury the availability of a kiosk that could be used by folks who are blind? Or is it, as the Supreme Court was suggesting, or Justice Kavanaugh was suggesting, the actual desire to use, that subjective aspect to it. To use in an economic defect context, for example, a vehicle that has a latent defect, does it have to manifest in order to have injury? Or just having a vehicle that has a design defect that may manifest, is that to injury? So these are much more difficult questions, I think, that need to be answered, and those are the ones that I think are going to drive much of the litigation going forward.
And I think that's a more interesting question anyway. In an antitrust context, is it the actual compensatory harm, or is it harm to competition, lack of innovation, lack of choices? I mean, there's so much more, right, than just monetary damages. But anyway, I think that's the more interesting question.
All of this is interesting to me, and I will say we should probably move on to another topic because I know we have other things we want to cover. But are there any cases that the audience should be paying attention to that are percolating in the space that may ultimately make their way back up to the Supreme Court and bring some clarity to this open question?
Well, it's interesting. The auto context ends up supplying a lot of precedential law across class actions in the U.S., and I suspect it would probably spill over outside the United States too. So keeping an eye on the class actions where manifestation of defect or lack of manifestation of defect is an issue, and there is a split among the circuits. So we're likely going to see one of these cases get up to the Supreme Court at some point. There was some hope that Johnson versus Nissan was going to make it to Supreme Court, but ultimately I think they're going to deny or have denied cert on that.
Okay, well, shifting gears to another open question in terms of Supreme Court precedent. I believe the Supreme Court has yet to rule on whether expert testimony is subject to Rule 702, which is, a Daubert, formerly Frye challenge at the class certification stage. And most courts that have considered this issue, to my mind, I think that's, 4 federal appellate courts in the United States, will allow full-scale Daubert challenges at class cert, while others, and notably the Ninth Circuit, where you practice a lot, Michael, allow only limited Daubert challenges. Hopefully I got that right. Are there any signals the Supreme Court is going to address this question anytime soon? Maybe starting with you, Michael.
It will. The Supreme Court is going to have to take it up sooner or later. And just for those who don't practice in the U.S. regularly, the U.S. is to class actions globally as the Ninth Circuit is in the United States to across the United States. It's the biggest circuit in the U.S., and there are more class actions filed in California than any other state. So that's why we are constantly talking about the Ninth Circuit. The Ninth Circuit tends to have a very love-hate relationship with the United States Supreme Court. It is the most reversed circuit in the United States as well. So it tends to set trends and then butt heads with the United States Supreme Court. The Ninth Circuit itself is a little bit Dr. Jekyll and Mr. Hyde on some of these 702 issues. Recently, in fact, this past August, there was a decision called Angeles versus Monsanto, which was not a class action case, and it was at the summary judgment stage, but it really made some clarifications on the application of Rule 702 to the trial court's review of experts. And many class actions, particularly those that deal with any type of scientific basis for the underlying issue, you'll have experts testifying, and the defense strategy is always to try to knock those experts out at class certification under Rule 702. And I don't know if that it's a correct statement to say there's for example, Daubert Light or a 702 Light standard in the Ninth Circuit, but it certainly seems that way. And I think the reason it seems that way, and to try to lend credibility to those judges who seem to have a lighter standard at class certification, the issue at class cert in terms of the expert focus is slightly different than if, for example, you're at summary judgment or at trial. The issue is whatever the expert is focusing on, does that expert opinion apply across the class? Right, wrong, or indifferent? Does it apply? And some judges will only look at that issue and say the theory that the expert is putting forth does apply across the class. Now, whether that theory is supported, reliable, based on correct methodology, I, as the federal district court judge, am not going to look at that at class certification, because that's, to me, getting into the merits. I'm only looking at the theory and its application. And then what ends up happening, and you'll see there are a couple of cases, Sonneville versus Mazda being one, when you get to summary judgment, the trial court will then turn around and say, well, let me see if this opinion actually is supportable, reliable, based on proper methodology, and then decides, well, it doesn't. Now I'm knocking out the expert at summary judgment. And oh, by the way, that class I certified before summary judgment, well, now I got to go revisit that too because I don't have a viable theory for the class certification. So it's kind of, you see disciplined judges trying to focus in that way, coming out with results that don't necessarily make the most efficient sense.
Stacey, what's your perspective on these issues?
Well, I tend to lean with the Ninth Circuit and the Eighth Circuit as well, which would apply what was a more limited Daubert analysis at the class certification stage. And one of the reasons is that cited is that Daubert is there to protect juries from being swayed by dubious scientific testimony, and the judge alone is who decides whether a class should be certified. And I will say one thing that we haven't brought up is Rule 23C1A says the court determines class certification at an early practicable time. And so to me, there's some tension with a requirement that you do a full-scale Daubert analysis at the class certification stage with Rule 23 itself, which says you make this decision at an earlier time, or you can, or you should, right? That might happen before discovery takes place completely, right? So to me, it's not the time, class certification is not the time to apply such a rigid Daubert analysis.
And the rule certainly says that. But the practicality of the application of the Rule 23 bears no resemblance to 23C. And to some extent, it depends on the case. There are some cases where you can look at the issue and say, yep, this applies across the entire class, and we just got to determine the merits, and we can move forward. But those cases, quite honestly, are few and far between, at least in my experience. And anytime you're dealing with, for example, economic defect or some mass fraud marketing, the plaintiff's counsel are the one who want to get deep into the discovery, get all the information that and the claim is, I need all this information so that my expert can render an opinion in class certification. So the application of the rule is very different than the language of the rule. And when you spend a year and a half on certification, and you've done full-blown discovery and all the depositions have been taken and the experts are submitting reports, the notion that somehow it's an immediate and not well-developed record that's being put forth is just doesn't make any sense.
Well, the way the cases have developed and the way the practice has developed, I will grant you that. That's certainly true, and probably because plaintiffs are now forced into that situation. But if you did, what would happen if a plaintiff were to go and try to certify a class earlier in the case? I mean, you can imagine what the defendants would do to try to defeat class cert at that point. But anyway, I'm just pointing that out.
So it sounds like, Stacey, you're an advocate of the Daubert Light approach.
Daubert Light. I'm with the Ninth Circuit and the Eighth Circuit.
And Michael, your bottom line on this?
Well, I think the bottom line is whether it's class cert or summary judgment, there still needs to be a reliable basis for an expert's opinion. And the expert has to apply that methodology, that reliable basis to the opinion. Separating it out completely, again, leads to very inefficient results. We've had numerous cases where a trial court has granted class certification. In some cases, notice has gone out, which is most unfortunate for plaintiffs' counsel who are shouldering the burden of the expense of class notice at that stage in the litigation, only to have summary judgment granted in favor of the defendant because the expert's opinion ultimately turned out not to satisfy the requirements of 702.
Yeah, and that's worse for the class then because they're certified and their claims get dismissed, right?
Or the judge decertifies, which has happened in my cases where the court had decertifies the class following summary judgment.
All right, well, shifting gears a little bit to fee awards for plaintiffs' lawyers, want to talk about a recent decision, again, from the Ninth Circuit. This is Lowry versus Rhapsody International. And in that decision, the Ninth Circuit reversed the district court's $1.7 million post-settlement fee award because the district court failed to base that award on the benefits to the class, which received only $50,000. Although I believe the $50,000 was a statutory fee award, that a maximum based on a change in the law that occurred, in the midst of the litigation. Stacey, starting with you, was that a fair or unfair result?
I will make an overarching statement first. I mean, I think attorneys' fees in these types of cases, when a plaintiff's lawyer undertakes a case to represent a class, they do so much like litigation funders. There's a risk involved, and they do expect a risk premium because you go into the case. You could lose everything and not recover anything, and you've spent years of your time on a case. I mean, that's the risk you take. So when you do take a case and there is a recovery, you do want a multiplier on that, and that's the overarching piece of that. In this particular case, I think there's a little more nuance in what happened here. At the same time that the plaintiff's lawyers were litigating this case, the defendant had negotiated a separate settlement with the National Music Publishers Association, which essentially gutted their case. And so what happened then is the plaintiff's lawyers negotiated a claims-made settlement. So, the amount that the defendant would pay was up to $20 million, right, for claims made. But the pool of people who were harmed, if they took the settlement or agreed to settlement that was negotiated by the National Music Publishers Association, they could not also make a claim in this particular litigation. So what happened is the ultimate amount that the court believed the plaintiff's counsel recovered was something like, I think, $50,000.
Right.
So they said the actual value of the settlement you brought wasn't $20 million. It was only $50,000. So I think this raises 2 points, and I know it wasn't on your list, but one is I've thought this going 20 years back. If there is some critical proceeding or litigation or anything like that that defendants are separately involved in that will have an impact on a class action case, it has to be disclosed. And maybe in this case it was timely disclosed. But I've seen this happen in other contexts where a defendant may, it's a defense strategy. They'll settle out one case over here, and that way the class case isn't as costly, right? So there has to be some mechanism for bringing that awareness to the table, because I think that would be important for the plaintiff's counsel to understand that as they're moving forward in the case. And I think the second potential impact of a case like this is it could make, and I think could be problematic for defense counsel, it could make plaintiff's counsel rethink claims-made settlements, frankly. So that could be an impediment for you guys as defense counsel. You're smiling, but I mean, if you have to think about what that practical impact will be on your practice, right?
I'm smiling because I actually had to litigate a fee dispute right after Lowry, and the federal district court judge actually asked me during oral argument, Mr. Mallow, do you really think that there should be a strict application of Lowry, which means that I as a federal district court judge, have to take the amount of claims and essentially take 25% of that, and that's all the plaintiff's counsel would get. And in that case, the total claims, I think, were maybe $500,000 in a case that had been litigated pretty rigorously for about 6 or 7 years. And the plaintiffs in that case were seeking, I think it was $11 million. So I was in the unfortunate position of having to answer that exact question, which is, do you really think there should be a strict application of Lowry, which means I can only give these folks a few $100,000. Unfortunately, I gave a truthful answer, which was I don't think it should be a strict application, but Lowry certainly is a guiding limiter on how much counsel should get. And then the judge asked me, well, what did you think they should get? And I said, well, probably about $2.5, maybe $3 million, which is what I thought the value of the work and the value of what was done, notwithstanding Lowry. And of course, the court used my quote against me in the decision when the court actually said, I know Lowry's out there, but I'm going to give these folks $8.5 million anyway. So the case is obviously up on appeal, but it is a very difficult question because you are correct. I want to be able to settle cases. I want to settle cases on a claims-made basis. But if Lowry is in fact interpreted literally, then plaintiff's counsel will never agree to those settlements, even though in the grand scheme, that type of settlement is far more economically advantageous to my client than in doing a common fund where millions of dollars are going to end up, essentially either on Cypre or somewhere else.
All right, well, let's shift gears again because we're running a little bit short on time and we're hoping to have some time for questions from the audience. I wanted to talk about something I've seen a lot in my practice, which is government bodies coming in to my cases and, whether it's filing a statement of interest in a case as the federal government does in some of my antitrust matters from time to time or otherwise. One thing I know we've seen in private class actions is intervention asserting parens patriae standing. So although U.S. Litigation plaintiffs ordinarily can only assert their own interests, a state is allowed to assert its interest in the well-being of the populace. And that's where, we're seeing from time to time these government bodies coming in and asserting standing and intervening on a parens patriae basis. So starting with you, Stacey, in your experience, is this, a good thing, or are these state attorneys general looking to make a political splash and just trying to come in and throw the roar in the water?
So, in the best of all worlds, when you're litigating on behalf of a class, if a state attorney general comes into your case, it's great if you could coordinate, but that's not always what happens. And just by way of background, the parens patriae began as actually a doctrine that allowed the British king to protect people who didn't have the ability to protect themselves, like wards of the state or mentally disabled folks. But the expansion of that common law in the United States, it didn't have any limiting requirements, and the case law hasn't been extremely well developed. And so the problem arises because there's a lack of regulation and limiting factors, right? Unlike the requirements of what we've been talking about, class certifying a plaintiff's class, the stringent rules, well-developed case law, lots of parameters going around that. So to your point, an assumption that, there's an assumption that, attorneys general are adequate representatives of their citizens' interests, but there's a problem because sometimes they may be political actors or bringing cases just for politics, not necessarily what's in the best interest of an individual plaintiff or a class. And I think what's particularly problematic is if you have, a class that asserts a lawsuit, and then you have a state AG coming in maybe a year or even 2 years after you filed this class action. You have to ask yourself, who is really representing the best interests of that individual plaintiff or that individual class? So that's my whole passionate spiel on that particular topic.
I'm not going to vary too much off of your sentiments. I think the fact that you have overlapping regulatory actions, these government actions that duplicate class actions is very problematic for a couple of reasons. You're right. Sometimes there's a political motive behind the government coming in and bringing those cases. But most often, I think it's a money grab. And certainly, you know, when the government comes in and pursues these claims, they're looking at three things. One is injunctive relief, which seems kind of an appropriate thing for government actors to come in and ask. The second is oftentimes civil penalties, and some statutes allow for the government to get civil penalties that class plaintiffs cannot get. You can't get civil penalties in a private class action. And then the most problematic is this kind of consumer relief. And the consumer relief aspect is exactly what is being pursued in the class actions. And you can see kind of from the defense perspective, kind of the piling on of remedies, right? So, you know, all of the big auto cases in the U.S. and outside the U.S. So GM ignition switch, Toyota sudden and unintended acceleration, Takata airbags, Dieselgate, you know, all these, you know, kind of huge automotive cases, every one of them had a government action as well as class actions. And the amounts of money that were spent were eye-popping, you know, billions of dollars in each of these cases, paid not only to settle class actions, but to settle the government actions as well. Interestingly, you can see how the government actions and the class actions can kind of play off of each other in certain instances as well. So in a government action, you can see if a resolution of that mooting some of the claims in the class action, which is what you're talking about. And it is unfortunate for plaintiffs' counsel if, for example, the Federal Trade Commission of the United States takes on a case involving consumer fraud and basically ends up coming to a consent order that guts the class action, and the plaintiffs are essentially in the class action are just out of luck at that point. If the relief that the FTC has gotten, for example, mirrors what is being asked for in the class action context. But the reverse can sometimes also happen. In other words, if you have a class and you settle the class for, let's say, the consumer relief, you know, damages or what have you, the government can't then go back and try to get that same consumer relief because the class has released those claims. And essentially the government comes in and steps in the shoes of the injured class members when it brings its own government claim. And there's a Ninth Circuit case called Intelligender, so the state of California versus Intelligender, which actually held exactly that the California Attorney General cannot seek redress, consumer redress, monetary relief on behalf of the same class members who released their claims in a class settlement. So navigating these two, you know, two different avenues to consumer relief, A, can be very problematic for the defendants, but B, can be very problematic for the plaintiff class action lawyers as well.
Yeah, and I imagine that's especially so when it's in your case and they're not just bringing a parallel lawsuit in some other court, but they're intervening, and suddenly you either have to make nice with them or figure out how you're going to keep your class going when you've been representing the interests of these absent class members all along. I mean, how has that played out for you in practice, Stacey?
Well, it's interesting. Just take state AGs. I've had a case where, you know, we've been successful coordinating as a class with a few state AGs, and yet there are some other state AGs who don't want to coordinate. To me, that's just another variation of the problem, right? When you've got so many different state AGs and you have a nationwide class you're alleging. So if you ask me how that's played out, I mean, that's just one example. It's a little chaotic.
Yep. Okay, well, we have about a minute left. Do we have any questions from the audience? I did promise to try to field some. Somebody must have a question. Over there, yes.
Hi, it was a very interesting panel. Out of curiosity, you've talked a lot about the issues with the system that you find, the conflicts you run into. Looking more globally, are there any traits of emerging class actions regimes or established class actions regimes that you think would be beneficial to adopt in the US? I know that the US is the class actions leader, but are there any emerging elements abroad that you think might be beneficial to integrate?
Can you repeat that? I had a hard time with the microphone.
Sorry, how's this? Can you hear me? No?
Maybe try not using the microphone. I thought it was my rock and roll ears, but I think it's the echo from the microphone.
Yes.
Yes.
Right, okay. Out of interest, I know the US is the class actions leader globally, but looking abroad, are there any elements of class action systems in different jurisdictions that you think that the US could benefit from adopting, just out of interest?
The question is whether the U.S. could benefit from adopting in its class action practice some of the regimes or practices outside the U.S.
From the defense perspective, requiring opt-in would be great.
Agreed.
You know, I was actually thinking about this last night. I think that in the U.S. we have such a developed class action regime. I was trying to think. I mean, I'm not defense counsel. I was trying to think: is there anything that would be interesting to adopt? But I couldn't think of anything, frankly. Not yet. Maybe give it some more time, and and there'll be some other things that will pop up.
Okay, well, I think we're out of time, so let's give a hand for our panelists.